Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so I can answer your questions. I do have a very, very important update for you tonight. So I'm going to give the update. You put your questions in while I give the update. And if you have questions about the update, also put your questions in the comments. Now, there are two updates that I have to give you. And as usual, it is not the best information, but I have to keep you informed about this so that you know how to empower yourself through the immigration process. As you know, Trump is terminating hundreds and thousands of legal immigrants pathways. So, for example, parole for certain immigrants who are here, and that's adding up to hundreds and thousands of people who are now, once it expires, are going to. And these are Haitian immigrants as well as Venezuelan immigrants through the parole program, and because of that, they are going to be vulnerable to deportation. And that's going to add to the numbers that he has and the goals he has to actually carry out mass deportations, because then you have a whole population of people that will be now susceptible to deportation. But what I say here is definitely make sure that if you are about to lose your benefits in parole, that you get in touch with an immigration lawyer. That's exactly what we help with, to see what kinds of options there are available. Now, the other thing is I have been seeing that he's going to ramp up his speedy deportation efforts by, of course, using expedited removal. So that means that he's going to start issuing notices to appear, and also through ICE enforcement, find anybody who's been in the country for less than 2 years. And that does include those who have been here on parole or who have been in the country for less than 2 years. Now they are going to be vulnerable to expedited removal. Now, the reason why expedited removal is you should be cautious, or you should be very wary of expedited removal, is expedited removal means there's no court. Within 24 hours or 48 hours of them identifying that you should be deported through expedited removal, you'll be on a plane and out the country without even seeing a judge. However, what you need to keep in mind in that case, then if you cannot return to your country because you will be persecuted, you need to state that you need to state that to the officer. If it's clear that you are about to go through expedited removal, that you do indeed qualify for expedited removal, you need, and of course, the number one thing you should have is an attorney. This is why it's so important right now to make sure that you have an attorney, because this does make a difference. Having an attorney who can get in touch with them or file the right documentation to keep you from going through expedited removal is essential. If you in that time you don't have a lawyer, at what I am going to say, the exception to expedited removal is asylum. If you fear going back to your country, and of course it has to be true, you can't tell lies, of course, you can't make up a story to be able to delay any expedited removal. But if, for example, I know many Haitians and Venezuelans will have a basis for asylum. If they haven't already filed for asylum, they will have a basis for asylum where they have to go through before a judge to have the judge hear their asylum case, because the conditions in the country are so bad that a fear of persecution is a real thing. And so you just have to keep that in mind. If you are fair going back to your country because you're going to be targeted, you're going to be harmed, that's where you need to state your fears very clearly. They will put you through a credible, fair interview. And once you get through, if you do pass the credible, fair interview, they'll put you on the regular track to go before a judge, apply for asylum. And then once, now under the current rules, once you apply for asylum, you still would be able to get a work permit. Now, it also depends on whether they're going to continue to detain you or they're going to release you. If they detain you, just know that you do have the right to apply for bond, right? And that can be done within 10 days of you being detained. So that's another thing. If you're ever detained, know that you can get bond to come out and stay out of the tension while you're going through your court process. If you're applying for asylum, then at that point you would be able to and you're released, you'll be able to apply for your work permit, and that can at least help you to support yourself while you, of course, make your case to the judge as to why asylum is going to be it in the alternative withholding of removal or convention against torture. Now, the other major news that has come out here, of course, we know about the registrations. Now, I talked about that in another live, but registrations, and now they're talking about issuing notices to appear after a case is denied before the USCIS. So that means that they would transfer your case to the immigration court if your case is denied and you are not lawfully present here, or you have a criminal record, or they see misrepresentation in your file. Misrepresentation are like lies. Anything that was willfully omitted from your application can be seen as misrepresentation or fraud. If they do identify that, then they may go ahead and transfer your case through a notice. So you get a notice to appear. This is not a new policy under the Trump administration. So under the last administration, that was their policy. And let me tell you this is why the stakes are higher. Do not hire a notarial. With a policy like this, everybody is at risk. So don't believe that because you are applying for marriage-based green card that you're exempt from this policy. Now everybody is going to be everybody. Employment-based applications, asylums, marriage-based. There is a question about whether humanitarian cases are going to be exposed to this. The memo that they released, that the USCIS released, it did not state that T visas, U visas, or Vawa were exempt. The regulations for the T visa, for example, do state clearly that unless there are national security concerns, they will not use the practice of issuing a notice to appear or referring to ICE. However, we have to see, we need more clarification here. But the assumption is, since they didn't mention any exemptions, the assumption is that everybody is at risk. Everybody. So this is not those who came into the country without permission, those who came in with a visa. If you overstayed your visa, if you came across the border, if you're going for marriage base, if you're going for employment base, if you get a denial and you can't show current status, then they have now said they're going to issue a notice to appear. So mistakes here will not, you need to know that mistakes in your case is going to raise that risk. So do not go for people that are claiming to be immigration specialists unless they're certified and they're specifically certified, and even they can't do the work of immigration lawyers. So make sure that you get in touch with an immigration lawyer. If not me, make sure you get in touch with a qualified, experienced immigration attorney that can get through your case, make sure that it goes through smoothly. You have more likelihood of a smoother process without with a lawyer than without a lawyer. So this is not DIY, do it yourself time. Okay. So keep that in mind. Now, going forward with this notice to appear, as I said before too, this was a policy that was in place. So I am very familiar with it. One of the things that I did notice were green card holders. So going into a citizenship interview, even if your citizenship is denied, and they find fraud, they find a mistake that you shouldn't have gotten your green card, they find past fraud, they find a criminal record. I did see a lot of notices to appear in those cases as well. So this is where I'm saying nobody is really, everybody is going to face a risk. So this is going to be a part of life. Is also considering that risk. Now, are you better off not applying? Because I know many of you are also saying, well, I'm just not going to apply. And the way that the conditions are set right now is the ICE and immigration enforcement are getting very aggressive. So they are behind on their numbers. And I think that's why they're really trying to ramp up. They're trying to throw people out of status, out of the humanitarian relief, the parole for those who got from Haiti and Venezuela, because this administration is anxious to meet the numbers that they promised, and so that means that everybody is vulnerable. And so I would say this: having nothing at all makes you more vulnerable, because it's not a situation where they're just going after criminals. They are targeting anybody that they come in contact with who do not have their papers. And at the time, if they encounter you and they detain you and you don't have anything on record, then it gets a lot harder to fight, not to go through expedited removal or to fight in immigration court at that point. Having your case can also get any kind of get you out on bond, and it can actually get your case terminated in some cases, because now the judge realizes, oh, if it gets that far, the judge will realize, okay, you have a case pending. It looks like you will prevail in your case. So they're going to go ahead and terminate or continue. When I say continue, I mean delay your case until your other case is approved. So get in touch with us so we can talk to you about your options, because the stakes are high. You don't want to gamble. Don't want to gamble with your application. Here at ST Law Office, we only submit qualifying cases. So we do not, and this is exactly why we do the free initial evaluation, because we're taking cases where we do take cases where we believe in the success of the case, and we push hard for our clients. So we are not, and notarios don't do that, right? They just, if you give them the money, they're gonna take it and they're going to tell you anything you want to hear in order for you to pay them, and then for them to file a sham application. And when that happens, that puts you at risk for misrepresentation or fraud. And when they find misrepresentation or fraud, then you become a priority for deportation. So important. Get in touch with us. We are a safe space. We'll be able to do an initial evaluation so we don't waste your time, we don't waste your money. It's done in a confidential setting. Then once we determine, looks like we can help you, we can get into a strategy session. We can talk to you. We can explain to you how we plan to approach your case, and then we can move forward. Also, keep in mind that with denials, there are other options that you can pursue. So, for example, you have appeals, and you cannot be deported. You're not deportable while an appeal is moving forward. So there's potential litigation as well. And push comes to shove, you may still have defenses in immigration court. As I said before, there are cases that only the judge can hear, like cancellation of removal. So you have this, give it, you have legal options. But if you sit down and do nothing, that's where you are going to be at serious risk. Um, Also, here's another thing. They do have the registration going. Right now, they haven't announced the official instructions. Right now, they said just sign up for your online account, but you can't register yet. They haven't released that. But one other thing I want you to keep in mind, and I think this is going to be a major trap for some people, and this is where having legal guidance is going to be very, very important. Um, when they do implement this registry, if it's allowed to move forward, because I'm sure this will be challenged in court, if there's no hold on this, registering this immigrant registration requirement, and you do not register, then you go ahead and apply for an immigration benefit, then they can look and see you didn't register previously. That may, because they also said failure to register can lead to criminal penalties and fines. So that, and you will become a priority for removal. It's a catch-22. It's a double-edged sword, right? You apply, you're basically saying, telling them you're here, this is where you are, because you have to provide your name, your address, your date of birth. But you don't apply, and you can face criminal penalties or fines. So that, and you become a priority for deportation. And then if you try afterwards to apply for a benefit, they may try to use it as a basis to deny your case now, because now they're saying you didn't comply, you violated the law, and you're subject to criminal penalties. We have to see if this is really going to be criminalized. They have stated that they're going to apply criminal penalties. That's questionable, once again, because immigration is not criminal, it's civil. But as we're going through these hoops at immigration, we can expect these kinds of responses. So it's really a double-edged sword, and this is why it's very important to see if you qualify for a benefit. And in some cases, if you have applied already for certain benefits, or you came into the country with a visa already, you do not need to apply, even if your visa is expired or you overstay. So that's something to keep in mind. And I did a video on it. So you can, if you go to YouTube, Getting the Green Card is my channel. You go to it, you'll be able to see the live I did on the registration. You'll be able to know, just by watching that video, you'll be able to know who's required to register, who's not. Most people, if you've applied for an immigration adjustment of status, if you've gotten paroled, if you've came in with a visa before, if you have a border pass, if you've applied, if you've entered, like say, overstayed your visa, I think I said that, applied for asylum, if you're in removal proceedings, then it means that you've already registered, right, through your process. If you are never got your fingerprints taken while you are getting your visa, if you don't fall under any of those categories, then you have to register. You enter the country without permission, and you didn't file for any of the applications I listed, then you would have to register. So go ahead, look at the video, and then also go to my link in the bio. I am releasing weekly newsletters that gives you updates like this. So you'll be able to get these updates. And I also provide a list. I sent out a newsletter. My past newsletter did have that information about the registration. So that's a good resource for you to keep in mind. So you can click on the link in the description of the video, get to the website. If you sign up on the website or you go to Linktree, you'll be able to subscribe as well. All right, so a lot going on. We'll have to see. This is not strange, though. I did practice under Trump's administration. That was implemented during his administration, and I did see some of the effects of it, especially when it came to citizenships. Ironically, we're going to be seeing it. It's probably going to be more citizenships and adjustment of status, and yes, denied marriage-based cases. I did see a lot of people would call me and tell me about the notices to appear they were getting after their naturalization interview, and they failed it. But they failed it, and something was discovered in their application, not because you failed the test, but because they found something like a criminal record misrepresentation in the past. Then they would say, oh, you don't qualify for citizenship. As a matter of fact, expect a notice to appear. So the point here is just make sure you understand the stakes are high. We are basically all in it. Everybody is going to be on the same playing field in regards to risk here. It's just going to be a part of the process now. Now, another thing to keep in mind is right now we have 3.5 million cases going through the court. Cases are being scheduled through many years. So a few years from now, 3 years, 4 years, 5 years from now, because the court they're inundated with millions of cases that judges have to hear. And that's why Trump is going to try to use expedited removal for some immigrants, particularly those that may have gotten parole and recently entered the country, those who may have recently crossed the border. So just be aware that you want to make sure you look at your options, because options here means expedited removal may not be on the table. Again, you may not qualify for it because you have those options. So get in touch with us. Go to the link in the profile, and then you can. Now what we do is just submit your information, and then our team will do the evaluation for you, so we can. And it's confidential. We can evaluate what potential options you have, and then we go from there. It's a safe space. It's confidential. So, just take that step. It's important. Now, I want to go ahead and answer your questions next. So I'm going to go and I'm going to start with TikTok and answer some questions here and then move across. So if I'm looking over here, it's because I'm on TikTok, and I'll definitely move from platform to platform. All right. My work permit renewal is taking forever. They still have the extension. So they still have that 540-day extension in place. Make sure you use it. When you apply for the renewal, you got your receipt notice. The receipt notice contains the extension. Keep your expired card and the original receipt notice showing the extension, and that's the same as having a work permit for the next year and a half. After you apply for EAD from asylum, will you get any notification or any information? 30 days after, if you apply timely and within the time you should, you're going to get that note. You're going to probably get the EAD 30 days after. We've been getting it exactly 30 days after we apply at the 150-day mark, because you're supposed to be issued your work permit 180 days after you apply for asylum. you're supposed to get the work permit at 180 days. You apply it to 150 days. What is the requirement, age 18 or 21, for someone to get married so they can to petition a person? So when it comes to marriage, there is no age limit. I mean, of course, keep in mind, age is going to come into play when they're looking at the application and trying to figure out if the bona fides are there, or if it's a legal marriage. Because if it's an underage person, you know, then the marriage has to be legal wherever they are, so in the state they are. So there's that. But 18, if they get married at 18, then they can still apply for the marriage-based green card. They don't have to be 21. So that's one of the things with marriage-based. What is let's see. Thank you so much for the gifts. Thank you for the love. Thank you so much. What does it mean when an I-131 case is closed? So I'm not sure why it's closed. You know, if they close it, then I would want to know, was there a decision? What happened? Was it denied and then closed? Were there any responses or lack of responses? I would have to know more for sure. What is the, let's see, is it normal for green card to take over 90 days after immigrant visa fee has been paid? So usually the card comes within, I would say 2 to 4 weeks. 90 days, that may be going on the long side. Contact them to make sure it went to the right address or to find out what's going on with the case. Thanks so much for sharing the live. Share the live, share video on YouTube, share it on Facebook, Instagram, because this is how we get information out to people, so you can make informed decisions, you can understand the policies, you can understand your options. Could you do a video explaining to us more about the TVs and the requirements? So I do that every day here, and actually we work on TVs as here at the law firm. So yeah, I do many videos on the TVs. Now, the way that we approach it is going to be dependent on the case, the specific facts. No two cases are the same, really. But the first is to redetermine whether you qualify, and everybody, as I said, is different. Now, for everybody, anybody new here, I'm going to just talk about it a little bit. T visa is for victims of labor or sex trafficking. Now, I want you, if you are not informed about trafficking, if you've been, some of my friends here, you've been with me for a while, so you know you probably even know what I'm going to say next. But for those of you who are new here, I want you to take out of your mind what you think trafficking is, because many people think about, and I used to, before I started to focus my practice on trafficking, I really was not informed about it until I started to learn about this and the options available and how prevalent it is. It is so prevalent for people here who don't have their papers. The abuse, the exploitation is so prevalent that many cases fall under as qualify as the T visa. Now, get out of your heads about trafficking. When I initially thought about trafficking, I thought about what I saw on TV, somebody being kidnapped, or what you hear, people being kidnapped in Walmart parking lot. Not to say that doesn't happen, but it's much more prevalent in terms of in other ways, where there's no physical force, there's no physical violence. It's more about mental and emotional coercion for some people when it comes to employment, when it comes to close family and friends, that force people to do things for them, to work for them in their house or in their business. And they use certain tactics like fraud. Fraud counts as trafficking. If somebody lies to you and tells you that they'll give you this, they'll give you that if you go ahead and come and work for them. Most times it's, I'll get you the work permit. I'll give you, I'll apply for your green card when you get here. Just come and work for me. Or when you are, if you're may already be here and they lure you to come work for them in some way, shape, or form, using those kinds of great promises. And then when you get into the situation, they never plan to do that. They never plan to give you papers. They never plan to give you whatever they promised you. Their goal was to get you in that situation, make you work for free or make you work for very little, make you work for less, make you work more hours than you agreed to, make you do more work than you agreed to. That is called labor trafficking. So that, and I know if you're watching this, I know many of you are currently going through this, or you have gone through this in the past and somehow you escaped, you got out of the situation, you empowered yourself. If you're still in the situation, I want you to know that the laws are on the books, it's statute, you still qualify for relief. And now, and that is one of the, while they haven't explicitly exempted it, the policies in the T visa do state that they are not in, they want to focus on relief. They don't want to focus on punishing those who apply. Now that can change, and we can get further clarification that all applications, including T visas, are included in the notice to appear policy. But the policy, they really do also have to change the policy under the T visa manual, policy manual, because it explicitly states there that they are not in the practice of issuing notices to appear or referring to ICE unless there's a serious criminal or national security threat. But keep in mind, this is a situation that's changing. And I mean, this past week, we're dealing with day-to-day changes where we have to be changing forms that have to go out. Clients have to be re-signing forms because they will tell us forms change today and we have to go with it. So things are changing day by day. Another reason why it's very important to have an attorney have your back, because we're on top of those changes. All right, so with the T visa, once we determine you qualify, then the next step is we go ahead and we take our clients, guide our clients through a confidential process. There is a reporting requirement, and it really depends on what's going on. The goal of that is not to get anybody in trouble. It's confidential. You're protected throughout the entire process. So what I say is start with a conversation with us about the strategy moving forward, what you can expect, how we're going to handle your case. But I do want to let you know that this is a confidential process throughout the entire process. So nobody's going to be getting your information, hearing about you saying this or that about what you went through. All of that is between us, immigration, and any kind of relevant agency we have to also talk to. It's all confidential. Then we go ahead and file it. It takes about 12 to 18 months to get a decision. Once you get that decision, and it's an approval, which we are very careful about screening for cases. We want to make sure every case meets the criteria for it because the stakes are higher. Now, once it's approved, you automatically get your work permit. Family members get their papers and protection as well. If your family members are outside of the United States, they get their papers to come into the country to join you here on the T visa. Then you are able to also apply for your green card. So another thing is if there are any issues in your background, like misrepresentation, entering the country without permission, that can be forgiven through what's called an I-192 waiver, where they forgive they forgive whatever happened to allow you to get your papers. So we help our clients, we represent our clients, we don't leave our clients hanging, we don't leave our clients, we take them the entire process, and we're there for our clients the entire way. That's our T visa process. That's the T visa process. It is an option that a lot of people don't know about, but the trafficking, labor trafficking, sex trafficking is very prevalent. And once I know if you're watching this, you can relate to anything I've said, it's time to give us a call. I'm a U.S. citizen based on, I am a U.S. citizen based on asylum from Syria. Can I go back to visit and come back with no problem? That is a tricky question, especially now. And I would say be very careful with that, because they do look at you going back to a country that you said you couldn't go back to. I know certain circumstances have changed a bit in Syria, but do you really want to be in a situation where you're explaining that? You know, I would say I would want to talk to you. I'd have to figure out what was the basis of your asylum. Has the circumstances changed in Syria, to be able to inform you about any potential risk? Because keep in mind, even though it's extremely rare, they have talked about denaturalization if they do find fraud. And not to say you've committed fraud, of course, but it doesn't stop them from implying that some fraud, and stressing you out by now trying to denaturalize you because they're accusing you of fraudulent activity. So you want to, would really have to talk to you about your facts to find out if that could be an issue. Now, I saw somebody here say, do I have to register? Um, it's going to depend. I believe I also released a video on here. So I think I issued a video. You can go scroll back through the timelines. You'll see a video about who can apply, who can't apply. That would probably be helpful to you. And I don't know your circumstances. So another thing is evaluate your options. Is it possible for a defensive asylum case adjust status through marriage? Now, since you're in the defensive asylum, it means you're going through removal, and adjustment of status through marriage may be possible in court, but they will not do the adjustment of status in the USCIS unless they terminate your case. So it just depends. It depends on what your situation is. Now, if you're doing it in court, you have to meet a higher standard, clear, and that to show that you are in a bona fide marriage by clear and convincing evidence. That's a very high standard to meet. So, you have to really be good on the evidence. Is USCIS waiting I-751 interviews? So they are doing I-751 interviews, but I don't know if you waiving. I know. So they have been waiving them, but keep in mind, marriage-based the interviews are coming back, so you can expect an I-751 interview. Can a paroled Afghan national who entered the U.S. via the Mexico border last month apply for TPS? No. Afghan. Oh, so an Afghan, we have to see whether if TPS is available, you may be able to apply as long as you meet the requirements for the TPS. Now, if you are paroled, you are given permission to be here. If the parole expires, or while right before the parole expires, you need to also explore TPS. I have to check to see if Afghanistan is on TPS. I would think so. I was denied I-485 based on marriage last year, March. Am I going to be affected by the new NTA policy? So, whether they're going to go backwards is questionable, but I believe that they are going forward. But keep in mind that as long as you are without your papers, now you're going to be at risk. So this is where you evaluate your options. I don't know why it was denied, but if you want to get a second opinion, or if your spouse was mistreating you, and that is why you were denied and the mistreatment is connected to the denial, it's time to give us a call. If you're on F1 and you have a work permit, can you still file for OPT? So it sometimes, if you have a work permit and you've been working on the F1, that might take away from your OPT time. So it depends on whether you have OPT time after you've used some of the work time. What does it mean when a case is closed? So I'd have to know what the situation is and what case is it. Removal order that has been dismissed in 2012, is that safe to travel with advanced parole? I would say no. But keep in mind, I'm not your lawyer. I can't give you personalized legal advice, but in general, what's happening, people with, I would say, past removal orders, people, and you still haven't had your papers yet. So it's not like you have your green card or you have your citizenship. So people who have removal orders, even green card holders are being held, either being reissued notices to appear, or are having their work permit taken away. So and maybe even having entry denied. So I'd be very, very cautious. Just now is not a time to think about traveling. If you have to travel, you need to make sure you understand fully the risk. If you did 2 DUIs, can that make you deportable if you have a green card? Possibly. It depends on the state statutes related to DUI to see how it depends on the statute and whether it can amount to a crime involving moral turpitude. So we'd have to look at that. Whenever you're dealing with criminal offenses, you definitely have to give us a call. Based on current happenings, would you advise undocumented persons to file taxes? No. So traditionally, what would happen and what should be happening is the IRS is there not to communicate with ICE. They collect tax. They only deal with the taxes. So when they were talking about sending IRS agents to now do, I guess, immigration enforcement at the border, they were referring to potential tax crimes. Now, for example, this is another reason: when you pay taxes, you follow the law. And also, filing taxes has always been looked at positively if you have to use it to show good moral character, or to show you've been compliant with the law, or to show you've been residing in the United States. If you need to show how long you've been residing in the US, filing taxes has been advantageous. Also, keep in mind, filing taxes is not unlawful. You're not breaking the law. You are following the law, because if you're here in the US, even if you're undocumented, you are required to pay taxes. So actually not paying could potentially be a tax violation, because anybody who meets the requirements who are residing here they are under the jurisdiction of the IRS, must pay taxes. So I would say here, complying with the law is always the best thing. The traditions of the IRS has never been to take a law-abiding tax individual who's paying their taxes, refer them to ICE. That has not been their function, and I haven't seen or heard anything differently. So what I would say is just make sure, follow me, because I also do ITINs. I also submit for ITINs, and we haven't heard any changes there, any differences there. ITINs are tax identification numbers to enable immigrants to pay their taxes, and I haven't heard anything differently. So I'll keep you up to date, but all is going as normal with that. We may expect longer times to get the ITINs though, just because they are cutting the staff workforce. What is the timeline for European people? There are different laws about them. So no, there are no different laws. If you're on F1 and you have a work permit, can you still file for OPT? Okay, so I answered that. Thanks so much for the follow and the love. I appreciate it. How you can get a green card on removal proceedings. So it's cancellation of removal. So if the judge, you present your case, and I believe I did another video on cancellation of removal. But if you've been in the U.S. for a certain number of years, usually 10 years, if you don't have your papers, you have good moral character, you have certain U.S. citizen or resident relatives, spouse, parent, child, and they will experience extreme hardship if you end up leaving the country. The judge can turn it around and grant you your green card. So this is where I say to keep in mind that it's not the end. A notice to appear, while nobody wants a notice to appear, of course, the goal is to get your papers at the USCIS in a much less stressful process. Keep in mind that you do have to go through a process and you get an opportunity to make a case as to why you shouldn't be deported, and you have potential options there as well. So I-360 denial will get the NTA. Right now, I would say this, the memo that was released does not exempt any group. Traditionally, they have not done that for humanitarian base, or they only did it in extreme cases where there was like criminal violations, a person was wanted, there was a national security threat. Then in those cases they did, but in this case, nobody. They're saying once a case is denied and they don't have their papers here, they're going to issue a notice to appear. And so they haven't exempted anybody, but policy manuals, which lay out regulations for those case types, have talked about confidentiality, the restriction on exchanging information between agencies because of the confidential nature of this. So those are also laws and regulations that we can cite to avoid NTAs by showing that under the law they are protected. But right now the memo is saying everybody. So the ones that I've seen in the past the past Trump point 1.0 that I saw were a lot of marriage-based denied cases got NTAs, anywhere they saw misrepresentation or fraud, and some who went for citizenship, and they found an error in there. Not an error, well, it may have been an error, but they would amount it to misrepresentation. Been married over 2 years and I-485 pending 18 months. Says case decision. Is that accurate? I'm not sure if it means case decision. If you have a decision, you need to call them to find out why you haven't gotten it by mail yet. Overstayed my time by 20 days before filing for marriage-based green card. Is that a bad thing? If you are married to a US citizen, then it should be okay. What is the required age? To answer that. All right, I'm going to move on to the next platform. I see here. Hi, attorney, and thank you for your help. How much time it takes for USS to respond back to annoyed? So I would say about, so I've seen it as little as 4 weeks, and I've seen it as long as 4 months. So we have to see there. Been married over 2 years and I-485 pending. Question, can you go to Jamaica as a US citizen and marry and file for your husband? Yes, absolutely. Absolutely. That's usually the way it works. Should someone be worried about getting deported if he gets MILPIP and pending AOS? You have a pending AOS, it should be fine. I would say you just have to make sure your case is going well, that everything is done, all the T's are crossed, the I's are dotted, so you don't have to deal with that stress. What's processing time for C31 EAD? So about 2.5 to 3 years. And that is the basically for Vawa. All right. Okay. I have my little puppy here and I hear him chewing on something, so I had to look and make sure he wasn't chewing on something crazy. All right, so now I'm on YouTube. Hi there. Hello. Has anybody on clients got EAD from getting BFD? How long is it taking? So the BFD is taking 70 to 90 days, and then it's taking another about 3 months to get the work permit. So it's taking a while just because they, after making a decision on the BFD, then they process the work permit. I would say the work permits are coming in about 3 months after, but expect even up to 6 months after. Also, we have been getting them. So that's the good news, is we have been getting them. So nothing has stopped there, because I've heard some people say, oh, they're going to stop the T visas. It has not stopped. We're still getting decisions. I just got a decision on Friday. So I'm really happy about that. And we got a number of BFDs. So that's the bona fide determination letter. So they're coming through. My marriage to USC I-485 interview is waived, legal entry overstayed, no criminal record so far, no RFE. How likely are USCIS to change their minds and demand an interview? So I still have, I've gotten a waived marriage base, and this was a really complicated case that we overcame at the USCIS. So that one was waived, even with the complexity. So, so I would say if you were in the final stages of your marriage-based process, you may still get it waived if they're just in the decision phase. But be ready for anything. I would say make sure you're preparing for your interview. Make sure the both of you are ready to answer those questions and to present yourself to the USCIS. Do you have a question video for the spouse interview? Yes, I believe I do. So if you scroll through, I think I just did one on the marriage-based 10 mistakes to avoid in the marriage-based process. I do cover the interview there. Some red flags. I would say this: from the time you submit your application, you need to make sure you're submitting a solid application from the start, because you're setting the tone. If you submit, so people that do it themselves, they're not lawyers. So of course they look at this as filling out paperwork, and they just send in something that frankly is really shabby. And so when the officer gets it and it's that shabby, it doesn't really meet the requirements, that officer is just going to schedule the interview, and that officer is going in with being very skeptical about the marriage, because you've already laid the foundation with a very shabby application. So I would say make sure you are prepared for that interview. The interview is sort of like the last chance. That's where you have to bring all the additional evidence. Make sure you bring all your original documents that are required to the interview. Make sure you and your spouse have prepared, to know what the questions could be. So, for example, start taking note of your routines together, your home, where you sleep, what side of the bed you sleep on, who likes to cook, who does what, what are the responsibilities. I do have, let me tell you, to go to the description in the video on YouTube, Facebook. And on Instagram, go to the profile. On TikTok, go to the profile, click on it, and I do have a marriage-based interview guide there. That guide also helps me to prep my clients for interviews, and it's been really great to use that guide. And I believe there's also another guide that talks about mistakes to avoid throughout the process in preparing your case. So those would be good guides. Just go ahead and sign up there, and you'll be able. So once you sign up, subscribe and you'll get the newsletter, which is released every week. So I do release the newsletter. The newsletter tells you the latest types of policies that are coming down the pipeline. So it would be good for you too. All right. I received my I-360 prima facie determination letter. What chance I have now? So the prima facie is good news. It means your case is going in the right direction. And it often means that it can offer you some protection from deportation. Having that, bring it everywhere with you, that prima facie letter. It can provide you benefits that you may need in the state to help maybe get you back on your feet. In some states, you may be able to use it to get your identification. So that's a good thing. Now, chances, I would say I would have to know your facts, because this basically just is a placeholder to say this person is going to have a certain level of protection until we can make a final decision. It's not indicative of an absolute approval, but it means that initially when they looked at it, they said, okay, from the look of it, the quick look over of it, looks like you meet the requirements, but they're gonna have to take a better look. So do you work with the U visa? Absolutely. We just got our client's work permit through the U visa. I have an approved I-130, 1.5 years now. I was married to a USC. I have advanced parole and EAD. How long do I have to wait for I-360 approval? Does having this I-130 lessen the wait time from 41 months to wait? No. It doesn't necessarily, but it does help with proving bona fides, but it's not going to lessen the time. Hello, good night. How long does it take to get work permit after approval for the T visa? You're supposed to get it right away. So as soon as you get the notification, I would say a few days to a week later, the work permit comes. Amen. I say the same, Patricia. Good night. How long to get receipt from Vawa application? So we notice things are slowing down a bit. So I often say 2 weeks to 8 weeks, because I've seen it around this period. I have always seen it take long, usually between the Christmas time and March. I usually see receipt notices take anywhere from 2 weeks to 8 weeks. So it might take that long. Okay, so your Vawa work permit will expire soon. No, you do not. Right now, there's no fee for the Vawa. That might change because they just made it 0 fees. Now it might go back to fees, but they have to announce those changes. So for now, no, make sure you apply for the renewal before it expires so you can get the 540-day extension. How long it takes to get a receipt for Vawa? 2 to 8 weeks. Hi, Donna. Hi, Judith. I recently applied for I-130. Do I still need to register? The I-130 was not one of the accepted forms. But did you enter the country with a visa? If you enter the country with a visa, then you wouldn't have to register. And if you enter the country with a visa, you wouldn't have to register Yeah, so it means that you're exempt, but I don't know if you enter the country with a visa. So, Ms. Sharifa, if they don't know they're here in the country, why are they putting themselves on the register list? Just for them to look for people. So the register definitely isn't there to benefit anybody. It's not there to benefit the immigrant. So the way it's described is we'll give you proof of registration that you have to take with you everywhere. Um, it does not mean that you're getting status. While it does put an immigrant between a rock and a hard place because they're trying to criminalize not registering. Meaning, if you do qualify for an immigration benefit or you end up maybe going before an immigration judge, now they're going to say you didn't comply with the law and you committed criminal offense because you didn't register. However, at the same time, registering also means that you could you could be vulnerable to enforcement at any moment because now you're on this list and you're basically you can provide the information that they need to look you up to determine what your status is and determine whether they can remove you. So it really is a tough situation, but this is where I say right now, they haven't launched it yet. They have not launched a registry yet. It's to evaluate your options and if you entered with a visa, by the way, doesn't you don't qualify for the registry. But if I spend your time looking at solutions that can help you. What happens to my marriage-based green card if I apply for Vawa? So they usually put that on hold and then move forward with the VAWA. We have to inform immigration of that. So go ahead. Yes, you can DM. DMing, we have the team that will be able to get you set up. What applications are the USAIS currently working on, like year for VAWA cases? So I usually they go by processing times, and the processing times right now is more than 3 years, so a little more than 3 years. Do I need a lawyer for bail bond, or can I represent myself? So with the bond, I would recommend you do because you want to make sure you fully understand the requirements and that you have an advocate there. But you can request a bond hearing on your own. A lawyer isn't absolutely required, but here's where I say the stakes are really high now, and you want to make sure that you have the best to get you the best results. All right, I'm on Instagram. Thanks so much for your patience. What's the processing time right now for T visa? So I am seeing them taking a little over, so about 14 months. So I would say within from 12 to 18 months. Um, can you take the receipt notice to DMV for driver's license unless it's the extension? And I've been hearing the DMVs are giving some pushback on that, but you can use it to get the receipt notice showing the extension to get the extended driver's license. That is allowed, but if you are just applying for a benefit, a receipt notice alone may not get. It just depends on the case type too, by the way. But it may not get you your driver's license, just depending on what you're giving them. Good night. I'm waiting. Okay, so just send us another message if you haven't heard anything. So I see. Go ahead, Goddess. Mark, go ahead, put your question in so I can answer. Does T visa need to involve a police report? No. Not necessarily a police report. It just depends on what the case is. And with the T visa, it's really on a case by case basis. I need to understand what happened in your situation to be able to determine whether the police report is required or another type of report. So this is where it's very important to call us, talk to us in a confidential process so we can talk to you and strategize and figure out what's best for you. Does T visa need to involve police? So I just said no. What are the options for someone in Canada on a postgraduate work permit? So I don't do who wants to migrate to the US. So it's gonna be like the rest. You have to give us a call because that one is very general. I'd have to understand what you qualify for. Do you have an employer who wants a petition for you? Do you want to come here as a student? That's what we need to know. So I see Goddess Mac with clean background. So if I call you at LSAP office for interview, should I be worried with pending asylum, parole in place, and credible fear? So if ICE right now, ICE they are doing some it's hard to tell. You do have a clean background, and they are saying they're not prioritizing anybody without a criminal record. If you're doing a routine check-in, you probably still have to do that routine check-in. There is a risk of detention if you're called in and ICE decides they want to detain you. There is that risk as well. But if you are going to routine check-ins, that might just be one of those as well. It's hard to tell. I'm 19, my boyfriend is 23. We are planning on getting married so I can help him stay in the country. Will the age affect me helping him? No, so you're over 18. If it's a legal marriage, it shouldn't be a problem. Thank you. You're so welcome. I'm glad that you're finding this information helpful, and thank you so much for the well wishes. Is there a class for citizenship? So if you're talking about the citizenship test, um, they have practice guides on the website. I have to check if they removed it, by the way, but they should have it there. And I did see here I have naturalization tomorrow, Marlon. Good luck. Good luck on that. I really wish you luck. My fingers crossed. So hopefully all goes well. It sounds like it will. So all the best. Good evening. Do you deal with VAWA cases? Absolutely. Yes, that is one of our focuses is VAWAs. And we're very good at it. So give us a call. It's been 1 year and 3 months since USCIS has received my I-130 and I-485. My case progress just stopped showing time, only saying concurrent. What does that mean? Concurrent means it's being considered together, the I-130 and the I-485, because I don't know if you file them together, but that's why. And 1 year and 3 months, is it 1 year and 3 months? Yeah. So, that's not excessively outside of the processing times. And, we can expect longer processing times now. So I wouldn't be alarmed just yet. If you came across the border and get detained already and got paroled out of detention, can you still be detained? You have the parole, but once the parole expires, they're not likely to extend it. And that's where the risk is going to be for detention. What if a person entered the country legally but got married? Entering the country without permission is going to prevent you from doing adjustment of status, unfortunately. If you are being mistreated by your spouse, then that is one way you're able to apply and still get your green card. But it just depends on what the circumstances are in your marriage. What is PIP, parole in place? So right now, we parole in place, they do give it to immediate relatives of US citizen military members. So that's one set of people that can get it. So if you have a military spouse, a parent, and you're under 21, or you have a US citizen son or daughter who is age 21 well, no, a US citizen son or daughter in the military, then you would be able to get parole in place. Parole in place, if you've entered the country without permission and you get parole in place, then you can apply for adjustment of status with the parole in place. Hi there, Mr. Rich Johnson. Good evening. Okay, that's gonna be it for me. Thank you, everybody, for your time. I really appreciate it. I am going to go ahead and let me see. I see my husband is having his U.S. citizen ceremony. Can undocumented people go with him? I would be very wary about that. I'd be very, very wary about stepping into any immigration office without an appointment, because you can be susceptible to enforcement. Can I get an approval 130 with a class misdemeanor? It depends on what kind of misdemeanor. So give us a call and let's evaluate that. My husband is having his U.S. citizen ceremony. Can undocumented people? Also, I answered that. Just be wary of the risk. I've asylum pending with NTA. Can I file Vawa even though I don't have enough evidence? This is where you definitely need to get in touch with us because you're in removal already. So we have to look at your VAWA. So with VAWA, while it's going through immigration, we can't file an adjustment of status until we can get your case terminated in court. So it all depends on what's happening there, but it's more complicated. But if you qualify for VAWA, it's still possible, but we'd have to just take another approach. So family on 10-year visa out of US since September 24, will they be able to enter first time long out? I'm not sure what that means. Now, keep in mind, 10-year visa does not mean you get to stay in the US for 10 years. So that's just one thing I want to make clear. You usually get about 6 months to stay here. If you overstay the time that you are supposed to be here, you are permitted to be here, then they'll invalidate your passport your visa automatically. So you may not be able to enter the US again because that visa would become invalid. I'm filing for my son. My son and his case is saying under review from August 8th, 2023. Is there a way, I think you're going to ask, a way to speed it up? It depends on if you have an urgent need to expedite. My BF lives in Scotland and I'm a US citizen. He wants to move here. What's the best route? So either a fiance visa or a spouse visa. So if it's a spouse visa, you'd have to get married. Fiance visa, you don't have to get married. You have to show that you have met in person in the most recent 2 years before applying, that the person who is the fiance in the US is a US citizen, that you do have a bona fide intent to get married once within 90 days of coming to the US on the fiance visa. The fiance visa, I would say expect about a year and a half for the fiance visa to come through, and then they would come here on that visa and then get married. If you choose to go to, get married and then file while your BF is outside of the country, then you're gonna be your BF would go to the interview at the embassy after some time, and it usually takes about 2 years for the process if they're outside of the US. All right. Once again, thank you. Have a good night, everybody. Thanks so much for joining me. I always appreciate the company. Make sure you go to the link in the profile. Right now, I always say this: let's focus on solutions. That's what's gonna get us through. So just hang tight, take some breaths, know that you are a good person, you're doing the right thing, you're following the laws, you've been here for a while, you've helped contribute. Good things will come to you. You just believe that. Believe, let's have hope, let's focus on solutions here. Have a great night, everybody, and hang tight. Bye bye.